Yes, Mr. Chairman.
Thank you, Lord. Good morning, my ladies. Good morning, my lords. I appear on behalf of the appellant, together with Mr. Evans, Miss McKenna, King's Counsel, and Miss Watts appear for the respondent father. This is an appeal from the decision of Mr. Warshaw, King's Counsel, sitting as a Deputy High Court Judge on the 22nd of April 2025. My lords, I'm aware, and my ladies, I'm aware that there's a live stream.
Yes.
And you'll have noted from the judgment of Mr. Warshaw that the children's name, and I use plural, the subject child and the non-subject child, were referred to as Daniel, not the child's real name, and Rachel, again, not the child's real name, and for the purposes of continuity, I will also refer to the child's name in those terms. The court will be also aware that both the mother and the father are observing this hearing by the live stream. The court will be further aware that permission was granted pursuant to the order of Lord Justice Peter Jackson on the 21st of May, and that appears at page 95 of the court's bundle, and in particular permission on all grounds, although Lord Justice Peter Jackson considered ground 2 was probably not as strong, but also granted permission in relation to the, or at least adjourned the issue of further fresh evidence, and Dr. Randall's report in particular, to this hearing. Subject to any preliminary review, I propose to deal with that issue firstly. My lords will see, and my ladies will see that that's set out at page, paragraph 7 of our skeleton argument, at page 21 of your bundles, and sets out the relevant law. This court, no doubt, will be very familiar with the authority of Ladd and Marshall, but also the case of Re E, in which the court further examined fresh evidence within children cases, and that authority is in fact in your authorities bundle at page 39 of the bundle.
Rather than looking at the law, can you help us as to what the significance, relevance of the report would be?
We say that, firstly, the fact that the child was going to be the subject of an educational psychiatrist assessment was highlighted within the bundle, and in particular the school report, which you find at page 203 of your hard copy bundles. That made clear that, in fact, a letter from the school, forgive me, 215.
No, I understand that, but I mean, what I meant is, what is it in the report that you say is of significance?
We say it's of significance that it underlines the child's particular difficulties. It underlines his attachment to the mother. It underlines his separation anxiety when leaving the mother, and that was observed by Dr. Randall when he observed the child on the 21st of March, and in particular it highlights his emotional dysregulation and emotional meltdown when separated from his mother, and issues which go to the heart of this case, where the court's effectively going to orchestrate a separation of this child from the mother. Thank you.
Let me hear from Miss McKenna. Miss McKenna, I mean, it's quite a detailed report. I'm not wholly aware at the moment of what its significance or relevance would be. Would it be better, rather than wasting time on it now, just say that we admitted de bene esse, and we can see at the end whether it actually is appropriate to admit it formally under Ladd and Marshall? Would that be acceptable?
I'm content with that.
Yeah. Okay. Thank you very much.
Thank you. So the background to this case, of course, is removal of both children from Ireland. The parties are both Irish nationals. Daniel is now aged 8, and the non-subject child, Rachel, is now aged 10 as of yesterday. The children have always lived together, and the mother has always been the primary carer of these children, and she sought to defend the 1980 Hague application by the father on the basis of 2 defences, namely the child's importance.
I think there might have been some issue in the evidence as to what the position was in terms of primary carer prior to the parent separation,
Yes.
but certainly since the parent separation in
16.
22,
Sorry, 22, yes.
the mother has been the primary carer.
Yes.
I thought there was an issue prior to that. I mean, just on the papers.
Primary care since separation, and of course, some proceedings in the Irish court, but they amounted in terms to orders for contact limited to 2 hours after school and 7 hours on alternate Sundays initially, but at no time did the Irish court ever order overnight contact, and indeed also made orders in relation to the father attending parenting classes, which the mother says he did not, and also being subject of a safety plan so that contact and handovers were always orchestrated in a public place.
Where do we get that from?
That's from the statements of the parties, and I'll ask my lineage to...
I mean, the proceedings were, I won't say extensive, but there was more than one court hearing.
There was.
And were they always just sort of interim orders? I mean, I haven't seen any judgments or...
There's no judgments as far as we're aware. What happened in February of 2024 was that the Irish court ordered a Section 32 report and allocated either a Kafkas-type worker or a social worker to undertake an assessment of the family. By the time the mother had removed the subject child in June of 2024, some 4 months later, that assessment had not started, and the worker, the allocated worker, had not met either parent. And indeed, a hearing in May was adjourned because the Section 32 report was not available. The father's circumstances, of course, are relevant, and from the evidence, we see that on separation he moved to his sister's house. The first order in the Irish court was the 23rd of June, which provided 2 hours of contact after school and 7 hours on a Sunday. It was the 8th of May hearing, which was adjourned because no Section 32 report was available. And at some point, the father then moved to live with his mother. He now says that he has a 3-bedroom property with his partner, but the subject child, Daniel, has never stayed, in fact, at the father's home. And it's clear from the evidence that he works full-time as a joiner from Monday to Friday, and at a time when there was conversations between the parties that he might come and collect Daniel from England, he was indicating it was not very straightforward because he had not booked time off work. The issues of the child's special needs are emphasised in the written evidence, where the mother says that in terms a 10-minute walk can take up to an hour, because not only is Daniel has his own special behavioural and social needs, but also as does Rachel, and so that a 10-minute walk can take up to an hour, simply getting them to and from school. At the time of the trial, the parties were awaiting the report of Dr. Randall, and that's clear from the school report, which we have. There'd also been a referral to CAMS, and they were awaiting funding for an educational health and care plan for Daniel because of his particular needs. And of course, the court will be aware that on commencing school in England, initially he was only tolerating 2 hours between 9 a.m. and 11 a.m., which was then extended from 9 a.m. to 1 p.m. So his attendance at school, where Ms Demeray indicates that it's only 68%, one of the reasons for that was that he was not present for the afternoon register, and therefore his attendance is skewed by reason of his limited hours in the school environment. The report...
That doesn't seem to have been the position when he was in Ireland.
Well, the position in Ireland, we have a rather rosy report. in terms of his presentation. And it's right that when one reads Dr. Randall's report, we see that when not dysregulated and when calm, he engages very well. And both the Irish school report and Dr. Randall and the English school report make reference to him being polite and appropriate and a joy to be with. But that's a very different picture when he's dysregulated. And as Dr. Randall makes clear, his dysregulation can occur at a moment's notice and without any particular trigger. One of the triggers is separation from his mother. And even when Dr. Randall saw Daniel on the 21st of March, he was sad and upset, did not want to leave his mother, was concerned about where his mother was. And as Dr. Randall makes clear, there's no reasoning with Daniel when he is so dysregulated. And he takes a while to calm down to a situation where he can be engaged and directed. That chimes with the evidence of the Kafkas officer, of course, who unusually attended Daniel's home address in Liverpool by reason of his special needs, social behaviour, and sensory issues, which the learned judge referred to in his judgment. But even she was rather shocked by his presentation on arrival. He refused to go to the train station to meet the Kafkas officer. He was uncontrollable either by the mother, but also Miss Demery, an experienced or very experienced Kafkas officer of the High Court team, was unable to distract him or calm him or make any efforts or achieve any efforts to engage him during the initial visit. So when we look at the report of Dr. Randall, and you have this at page 80 of your bundles, it's clear that in the opinion of Dr. Randall, let me just make this clear as well, my little friends in their skeleton argument complained that this was not the subject of a letter of instruction or a joint instruction, not an expert in circumstance. This was a referral from the school, and the mother, neither the mother or her legal team had any part in its instruction, referral, or the obtaining of that report. But it's a 15-page report. It's detailed, and we say it's the only objective and independent report as to the child's presentation, because the school reports, with respect, are written in rather rosy language to emphasise the progress and positive aspects of the child's presentation, rather than detail the real issues that this child in particular presents. And Dr. Randall points to the harm, significant history of adverse childhood experiences, which he abbreviates to ACEs. In his opinion, the ACEs are ongoing, although less severe, and the source of those ACEs, as he describes, are because of ongoing trauma. When he's calm and focused, he can engage and has progressed very well in maths in recent months, but his ability to engage in the school environment is compromised, and his basic skills in literacy and numeracy are operating at reception level. When calm, he's personable and polite and a joy to work with, but when agitated, quickly progresses to full emotional meltdown. And we say that's important in the context of this case, where this father has never, in fact, had the full-time care alone of this child. He engages in extremely violent and aggressive behaviours towards adults, and the triggers are predictable in the opinion of Dr. Randall, particularly when separating from his mum, but also something innocuous can cause him to become quite dysregulated. And of course, this was the example that he observed at page 90 of the bundle when he saw Daniel on the 21st of March. His observation when Daniel was in the entrance hall with mum.
Sorry, where are you on that
page?
page?
This is page 81 of your bundle, under the subheading Observation.
Right. Yes.
On arrival at school, he was holding on to his mum and presented as sad and worried, saying he did not want to leave his mum. When he did leave, he was extremely distressed and demanded staff call his mum back or take him home. Staff tried some alternatives, and by this stage, of course, he's been in school since November, and so these staff are very familiar with his particular needs, but they could not do anything to engage or calm him, and he was stuck on the idea of going home. He was violent towards staff and had to be physically supported to the calm area for his own safety and for that of others. When there, he continued to shout, demand, insult and swear at staff, kick, push, punch and spit. After 5 to 10 minutes, he began to calm, at which point he agreed to come to one of the staff's room to call his mum. He was not physically aggressive by that stage, but whilst on the phone to his mum, he persistently tried to tell her that she should stop any errands and come immediately to collect him. Following this, he calmed enough to engage with Dr. Randall. And that's a one-off, perhaps, but as I repeat, echoed by the observations of the Kafkas officer when she observed him. Over the page, at page 83 of your bundle, Dr. Randall opines a diagnosis of oppositional defiant disorder that lists 8 separate issues and indicates that the child consistently shows 4 to 6 of those particular traits. At the bottom of that page, halfway through that paragraph, under the subheading conclusions, he requires a stable, boundaried and well-structured school environment where the routines and adult responses are predictable and certain. And then towards the end of that paragraph, if we are able to provide the right environment, it will give the child the best chance to manage and overcome his emotional needs. And although it may not be straightforward initially to put this structure into place, I'm confident it will work with time and consistency. What is clear to me is that the child cannot receive the support he needs without significantly higher level of provision than is typically provided within mainstream SEN on offer. He will require an EHCP in order to have his needs met, and we will need to see how he responds to the provisions below before we are able to ascertain whether mainstream setting is able to meet his needs in the longer term. And then Dr. Randall sets out over a number of pages the particular issues to be addressed within the school environment and strategies to be undertaken to try and engage Ryan, the child. So that's those are the issues which presented the court, in particular with this child. And in terms of the judgment of Mr Warshaw, we have that at page 97 of your, page
Yes.
Yes, thank you. Page 97 of your bundles, yes. And at page paragraph 6, the learned judge sets out the agreed directions and authorities in relation to Article 13B. In particular, RE, making clear the burden of proof and the quantity or quality of the risk to be ascertained, no gloss or complication to be applied to the physical or psychological harm, and then rehearses the intolerability quote from Baroness Hale. At the bottom of that paragraph, the court fully understood and both parties made clear that this is a case in which he could proceed to determine the case and reach the outcome by taking the allegations at their highest. Paragraph 7, the learned judge then points to, even if the requirements of Article 13B are approved, I must carefully consider whether sufficient measures exist that can be put in place to ameliorate the grave risk that has been identified. What the judge doesn't do at that stage is make any reference to intolerability, but he had, of course, made reference to it in the previous paragraph. In terms of the evidence in relation to the risk, the learned judge had two particular sources. One was the report of Mr Emery, the Kafkas officer, and secondly, the expert report of Dr Racknam, who had undertaken a psychiatric assessment of the mother. The observations of the Kafkas report appear at page 107 of your bundle. As the learned judge points out in paragraph 45, Mr Emery is a very experienced member of the Kafkas High Court Kafkas team. He sets out in terms the circumstances of the visit, paragraph 49 onwards, and the particular language that Daniel expressed to Miss Emery when she arrived in the home. The mother said that Daniel wanted to speak to his father. The mother tried to distract him by saying that he was at work, to which he replied, "I don't give a shit that he's still at work, I want to speak to him now." He then made reference to a number of issues about England.
Or you can read that.
I'm sorry, this is paragraph 49.
Yes.
Daniel told Miss Emery that that should be Rachel, I think, not Daniel. She preferred England as it's safer, but was unable to articulate why. And then Daniel, at the bottom of that paragraph, wished to write a letter to the judge, which he wrote, "Dear Judge, bring me back to Ireland. I want to live with my dad," from Daniel. He then effectively packed his bags and left the property. On his return, made disparaging remarks about the house is crap. And that
It's all right, we can read, I mean, we can read this.
Yes. So, in her written evidence, the judge made reference to this at paragraph 54.
Yes.
No reason to be separately represented, but concluded that children are in the highest category of risk of emotional harm as a result of the combination of mental health, reported domestic abuse, and substance misuse of both parents. And also highlighted the devastating impact of abuse on children and the impact that might have on them in terms of forming future secure attachments. So at paragraph 55, importantly, the judge refers to Miss Emery's unsurprising conclusion that although, referred to her unsurprising conclusion that Daniel did not object or what weight the judge could attach to it, but he makes the point, "I certainly do take no account of Daniel's express wish to return given his very low level of maturity." As to defence of grave risk of harm intolerability, again, the learned judge sets out in terms, paragraph 49 of the Kafkas officer's report, at paragraph 56. And that, in terms, indicates that the court would need to be satisfied that if returned to Ireland, it would be safe. Daniel's emotional well-being would be recognised by the courts, police and the children's services in that country. And whilst she appreciated that no adverse findings had been made against the father to ensure the safety of Daniel, should he return, she recommended a referral through the Central Authority or the Irish Child Protection Services for a full risk and welfare assessment of Daniel and his father. Importantly in our submission, the last sentence is crucial because it also makes point that the court may also wish to be assured that there are alternative interim care arrangements for Daniel pending a welfare investigation. Now, Mr Emery gave evidence ostensibly in relation to the child's objections defence, to which she had been directed to file a report. She was not, of course, directed to file a report as to the Article 13b, and she was not undertaking any risk assessment of the child, and she was not giving a recommendation as to what the court should do in terms of a return order or otherwise. But importantly, paragraph 59, page 110 of your bundles, the judge refers to a significant exchange in which Mr Jarman asked a question and I asked clarification. And that is set out in terms thereafter. In particular, my question in relation to the Kafkas officer, you're not advocating separation of Daniel from the mother or placement with the father. Ms Demery makes a very clear point. I'm not making a recommendation. What I'm saying, if there's a move to father's care, there would need to be an assessment which chimes and is underlined by her written report. It would be preferable if mother and sister accompany him. They are the main sources of emotional security. As I said, I appreciate the courts of Ireland sees it would need a welfare assessment. I don't think there's anyone other than the father who'd be in a position to care for him in the interim because the mother's family have their own mental health difficulties. The judge then asks, if Daniel was returned to live with the father and the court is investigating, would you have any concerns? And again, Ms Demery makes the point, I would have some concerns given the history, although there's obviously a lot more to the situation. And she had made the point that she had not spoken to or interviewed either the mother or the father. Obviously, there's been no fact-finding hearing on domestic abuse that's been reported, but obviously that has an impact on the children, whether they are aware of it or not. It's difficult to know. And at this point, as we set out in our skeleton argument, the answer became somewhat rambling. But Miss Demery repeats, I have not concluded that much of a welfare assessment. There would need to be an immediate welfare assessment of him. I don't think he would be at risk immediately, if at all, but to be sure his needs are being met in that environment and there is an assessment, or otherwise he'd be living with father for the first time without his mother and with his partner, i.e. the father's partner, whom he may not be altogether familiar with. I'm not saying he doesn't know her, but it'd be a major change for him if the mother and Rachel do not go. I am just speculating, she says, that given how much disruption he has experienced, that there could be a reaction if and when he goes to Ireland, even in accordance with what he says he wants. That did not diminish, we say, the need for any assessment if this child was to be placed with the father. And we repeat the written evidence, which is not undermined by the oral evidence, that assessment would need to be done in advance of any placement of this child with these needs with this father. But the learned judge effectively then over-focuses on this particular aspect of the evidence. And at paragraph 60 makes the point, this evidence is very significant. I take from it there is no immediate risk to Daniel if he's returned to Ireland in circumstances where M refuses to return and he is thereby separated from Rachel and living with father, so long, in italics, as a welfare assessment is begun immediately. We say that effectively, having directed himself to the RE criteria and the discipline which my Lord Justice Moylan has indicated in other authorities, the learned judge effectively dismissed the allegations of the mother, which he says in terms are at the highest and are very significant, dismisses the evidence of the Kafkas officer, in which she says the allegations are the most severe and this child has suffered harm and would be at risk of further harm. And effectively determines that provided there's a risk assessment to begin immediately, in his words, in Ireland, then the Article 13b defence can be ameliorated and the child return in those circumstances.
So, Mr. John, one of your grounds of appeal is that the judge misdirected himself by talking about immediate risk.
Yes.
Is this the first passage in which the judge refers to immediate risk?
It is, and it comes, my lady, it is, and it comes from the oral evidence of Miss Demery, and he immediately, as he indicates in terms, jumps on this, my words, and determines that this is very significant, and because of Miss Demery's oral evidence, which came at the end of a very long answer, he says, well, provided the Kafkas officer says there's no immediate risk, and therefore in those circumstances I can return.
Yeah.
I'll come back to...
You're saying that the judge's description of this evidence as being very significant just overstates the position as well as being a misdirection?
Yes, a misdirection because it fails to consider holistically the whole of the issues which the mother relied upon to demonstrate risk. But also, he doesn't at that point, in fact, although he talks about the allegations taken at the highest, he doesn't make a finding that the threshold for Article 13b is passed. He simply goes on, jumps into amelioration and protective measures without, in fact, considering the whole situation, and particularly, as he directed himself, the very serious allegations that the mother was making against the father. Dr. Ratnam's evidence I can take quite shortly, but in terms, the learned judge at paragraph 81, and this is at page 115, 115 of your bundles, Dr. Ratnam gave oral evidence and gave 2 written reports, but in terms, the judge indicates that it demonstrates Dr. Ratnam considers the return to Ireland represents a significant risk for mother of deterioration in her mental health. 2 points arise. First, Dr. Ratnam was equally clear that staying in England in circumstances where Daniel returns to Ireland did not present such a risk. In those circumstances, although a deterioration was likely, it would be manageable. And second, the mother was adamant that she would not return to Ireland. Now, the fact that she was objecting to return to Ireland was as a consequence of the father's behaviour and a consequence of the impact of that behaviour on her mental health. So, whilst, again, the learned judge points to it being manageable if the mother stayed in England, it fails to recognise or understand or attach any weight to the fact and the reason why the mother was not returning to Ireland in the first place. The judge then sets out the issues in relation to the child, and I say that in terms, Dr. Randall's evidence is the most objective and independent evidence of that, which sets out the real concerns about his particular needs. But at paragraph 91, having summarised the evidence in relation to both schools in Ireland and in England, and also Miss Demery's evidence, at paragraph 91, he makes this observation. So what do I know? I know that Daniel is a very troubled little boy with very specific needs, whose troubles appear to have been exacerbated since leaving Ireland. Well, that's, we say, not an appropriate finding, where the evidence from Ireland is fairly minimal and only comes from the school, where in terms the detail of evidence in England is much greater, even without Dr. Randall's report, because we had specific questions asked to the school, which they had replied, but also we had a very experienced Kafkas officer who had experienced for herself just how difficult this child was on her visit to Liverpool earlier in the year. The questions, the judge directs himself, the questions of whether, in fact, the troubles have been exacerbated and why they have been exacerbated do not need to be addressed by me. But with respect, he placed some weight on the fact that, as far as he was concerned, those issues hadn't arisen in Ireland. And he goes on later in the judgment to make point that in Ireland the child had 2 support workers rather than 1. But I remind myself my task is not to consider Daniel's best interest, but merely whether or not the mother has raised a sustainable defence to this application. In terms of the mother's return, although the learned judge doesn't go through the authorities which we provided to him in relation to consideration of the mother's return and whether it was a genuine position or not, at paragraph 92, he makes the point and finds, I have no doubt for whatever reason, whatever decision I make, that mother will remain here with Rachel. So he's satisfied that this isn't a tactical position of the mother. She had indicated to both Dr. Ratnam and Miss Demery that she would indeed not return to Ireland, even if the child did. We then get to page 118 of the...
Well, first of all, in paragraph 24, the judge sets out 5 strands. Does that accurately identify the 5 sort of elements that you were relying on? Paragraph 94?
94, excuse me. Yes.
And so it's really A, C, D, and E.
Yes.
Yes.
Yes, because although we, of course, relied on Dr. Ratnam's evidence and that it was significant impact on her mental health, in terms where the mother herself was not returning, that would have had lesser effect.
Yeah.
But paragraph over the page then, at page 118, the judge then sets out the individual strands of those defences. The abuse, Mr. Jarman outlines in his written opening the extremely serious allegations of abuse against the father. The judge makes the finding. These are...
Well, does he deal with anywhere else, or this is his analysis?
Well, this is his
Your
own analysis.
is
It
that
comes under the subparagraph before of the parties' positions and submissions. So it's not in terms part of his judgment. And my lord, of course, last week before you, we referred to the engine room of the judgment. This certainly doesn't appear to be the engine room of the judgment.
But your submission is that he's accepting.
Well, he appears
that they
to be
are
accepting.
the various highest order.
I mean, part of the difficulty is that he appears to accept it, but then doesn't particularly reference either a finding in relation to Article 13b or having found the threshold met, how those risks would be ameliorated.
Yes.
What he says in terms, these are of the very highest order and include physical violence and rape. They also include examples of egregious, coercive and controlling behaviour, and it's submitted not a case which the court can confidently discount the allegations are true. I accept this submission. So on the face of it, that appears to be an acceptance that it's of the very highest order and that the allegations can't be discounted as not being true. But the judge does not go on to make a finding or consider or make reference to those allegations in terms of Article 13b. And of course, by separating out these individual aspects, the learned judge directs himself into some trouble because he considers the individual strands of the mother's allegations rather than the totality of those allegations when considering the Article 13b defence and the need for protective measures. Mental health, I think we've dealt with and doesn't particularly concern us today, but it does make the point, it seems to me, that the significance of harm would mean that the degree of gravity of risk needs to meet the Article 13b test would be much reduced. I have to carefully consider the case of Reed B, which he had been referred to. I consider that my approach is entirely consistent with its ratio. Daniel's needs. Again, the learned judge falls into error, we say, because what he effectively does is consider the way in which Daniel's returned. And we had submitted that a return to Ireland in circumstances where he's separated from the mother and plays with the father would exacerbate his needs and put him at significant risk. But the learned judge says, I struggle with this submission. Daniel had access to additional help in Ireland. Well, that help amounted to support works in the school environment only. A family social worker, that social worker had been appointed 4 months before the mother removed the children and had not made contact with the mother or the father. Access to that's the point that the judge was making, access to two one-to-one support workers at school. I think on a proper analysis, this submission may be intertwined with the submission that it's intolerable for Daniel to be removed. That's rather putting the cart before the horse. It's not assessing the degree of risk in those circumstances. It's not assessing and making any reference back to the particular needs of this child and the references that have been made by the Kafkas officer and indeed by the school of his dysregulation. Separation from the mother, submitted it was intolerable for Daniel to be removed from the mother on the basis that he'd always been his primary carer, but in any event since 2022. But the judge then says, this submission seems to wander into the territory of Daniel's welfare and best interest. We say that's entirely wrong. And it's entirely wrong for the reasons set out in the decision of Re A and my Lord Justice Moylan's judgment, where separation of itself from the primary carer can amount to an Article 13b defence. And in particular, we rely on paragraph 88 of that judgment in relation to that particular aspect. And again, separation from Rachel, submitted it would be intolerable. No reference, the evidence supports the submission that Daniel and Rachel have a very close bond, but there's no analysis as to the impact on Daniel should he be separated from either the mother or from the father. We repeat our submission, paragraph 100, which the judge writes into his judgment, must look at these strands holistically and decide whether or not the necessary threshold is reached. They submit to me that the protective measures offered by the father are not adequate, and they said the defence is made out. What the judge doesn't do in terms is make a finding that the Article 13b threshold is indeed made out. He then goes on to consider the submissions by my learned friends on behalf of the father and comes to his decision then at paragraph 107, page 120. What he does in error, we say, is then over-focuses on two particular aspects of the case. And he describes these as beacons in which guide his decision. The first is the Kafkas officer's evidence there'd be no immediate risk of harm if returned to Ireland and returned to the father's care in the context of a welfare inquiry. Importantly, the judge relies on an offers of undertaking to begin the process of that inquiry by making an appropriate application to the Irish court. There was no evidence before the court as to the timeframes. There was no evidence to the court as to how long any assessment would take. And there was no evidence before the court as to how the mother would engage in that assessment on the basis that the court accepted she would remain in England and care for Rachel in those circumstances. The judge makes a reference, this would presumably be an application for custody, so it's rather speculation from the court. Likewise, no doubt the mother could achieve the outcome by applying immediately for a relocation order, again without any evidence as to how from England and without funding that would be even possible. I made the submission that that may take many months in light of the evidence before the court, that it was already 4 months down the line and nothing had happened. And the judge accepts. I do not know how long such an inquiry will take, but I am quite sure the time it takes will be proportionate. Well, again, there's no evidence to that, and so that's simple speculation by the court as to that, rather to bolster his determination that the child is returned to Ireland.
But also, what does proportionate mean in this context?
Indeed. what does proportion? My lady is absolutely right to identify that, because of course the Kafkas evidence is there needs to be an assessment pending any placement, and so how would an assessment start in those circumstances? What would happen to Daniel if the very initial assessment indicated there was a risk, and how would he be protected or removed from the father's care in those circumstances? And having been sent to Ireland, what would that mean in terms of his interim care, foster care, where the mother's family weren't available, and as the Kafkas officer identified, the father was the only viable option in the circumstances, or potential option. The second beacon the court refers to is at 109, where the mother says she will not return to Ireland, and I believe she is telling the truth. There is no possibility of a grave risk of harm to Daniel arising from mother's mental health. Well, that's a beacon which is rather nuanced, and it's not as simple as to say there's no risk to Daniel, because, of course, what the court was advocating was a separation. And although her support in England was much greater than in Ireland, it was effectively an issue which guided the court's decision without analysing the impact on Daniel of separation, either from his mother or his sister.
So in other words, the beacon blocked the judge's view of Daniel's, the harm, potential harm to Daniel from the separation,
Yes.
rather than the mental health.
Yes. 110 again repeats the phrase, I must look holistically at these strands, but he's already effectively determined that those beacons are directing his judgment. And so the exercise in looking holistically has already been done or can't be done properly. And rather, he then dismisses the very severe allegations of rape and abuse, assault, controlling and coercive behaviour, saying no immediate risk of harm in the context of a welfare inquiry. Well, that, we say respectfully, is not the test. These are summary proceedings. The allegations must be taken at their highest. And having indicated that these were of the highest severity, the learned judge makes no reference to those severe allegations in the context of the mother staying here, the issue of separation, or how those very serious allegations feed into a placement of this child with this father. And of course, this father by that stage was living with a separate partner, and we have no evidence as to the nature of that relationship, the strength of that relationship, or how in concrete terms this child with his particular issues would be looked after by the father and his partner. We know that he was working full-time, that the mother in England was unable to work at all because she was constantly having to manage, even on a daily basis, the very significant issues of Daniel and schooling. And that the father had indicated in very clear terms that he worked full-time, and in those circumstances it would be difficult to be submitted for the father in any event to be a full-time carer. But again, that would be subject to an assessment.
If you go back to paragraph 111, when the judge says he was satisfied there was no immediate risk in the context of a welfare inquiry, what does he mean by that, or what do you submit he means by that?
Well, what he means is that as he relies on the evidence of Miss Demery that says there's no immediate risk where there's a welfare inquiry ongoing in Ireland. And so he conflates a summary process with a welfare process and relies effectively on the welfare inquiry in Ireland, commencing quickly, but also being alive to the issues before, or being alive to the issues that this child presents. What's not clear and not set out in any concrete terms is how long a welfare inquiry would take, and what would happen to Daniel if that welfare inquiry was negative. But it simply diminishes and dismisses entirely the first part of that paragraph, where he says the allegations of abuse made by the mother are the highest severity. he doesn't analyse how those severe allegations then impact on this child, where Dr. Randall makes clear, and the Kafkas officer makes clear, that he has been subject to harm and his behaviour is a consequence of harmful behaviours, arguably by both parents, but in the context of being parented by these parents and the impact that it's had on him.
I mean, I think what you are effectively saying in respect of these paragraphs of my decision, the judge just actually doesn't undertake a re exercise at all.
He doesn't. He doesn't identify the threshold. He talks about the utmost severity, but then doesn't make a finding that the threshold's passed. And then he doesn't analyse in the circumstances, importantly, the impact of separation and the guidance that you handed down in Re A, but as we made very clear, the impact on this particular child with these particular needs, and it's emphasised by the expert report of the educational psychiatrist.
And it is quite relevant that the Irish courts, as you point out, have not yet thought it appropriate to make an order that provides for staying contact, as we would call
Yes.
it, at all.
No, nothing. Very limited contact, in fact. Handover in neutral positions. And of course, at the time of removal, the father didn't have a guardianship order, which he subsequently applied for after the removal of the child from...
And that's just a sort of recognition of parental responsibility equivalent order.
Indeed.
Yeah.
And of course, to make an application to The Hague, he would have needed that to demonstrate rights to custody.
And that may be why, going back to the why Mr Emery said the court may also wish to be assured that there are alternative interim care arrangements.
Indeed.
And the judge doesn't seem to have engaged with that. The point you just made. Well, what happens if the Irish court actually decides that the child should not be with the father?
Yes.
What then?
Yes. What then, where he's accepted the mother's not going to go back, and on any basis, her circumstances in England are very limited, particularly in terms of finance, and her ability to go back to Ireland and seek to demonstrate care for this child would be almost non-existent. And then over the page, in terms of separation, the highest the learned judge analyses that is where he says separation of Daniel from the mother and Rachel is far from ideal. Well, that's a rather big understatement on any basis.
Also, it's not the right test.
It's not the test at all. Yes. And that's the degree to which that he does undertake any assessment, because he then goes on to misdirect himself. If I were applying a welfare standard, I would probably come to a different conclusion. He relies on positions where the mother relied on the father when she went to hospital. He accepts there are different circumstances. He doesn't make any reference to the behaviour of the child and the particular parenting issues that he presents. But I do not think that placing Daniel with the father, and he now uses a new word, temporarily, will put Daniel in an intolerable position. That's without any analysis as to what the intolerability for him may be, but also the importation of the word temporarily has no context in terms of any evidence as to how long this position may be in place, and in any event, again, doesn't recognise how the mother would maintain her relationship with Daniel on the basis that the court accepted she was going to remain in England.
Might there be... Oh, sorry.
No, go on.
I was just going to... Might there be a further problem with that sentence? The fourth sentence of paragraph 113 is that the judge appears to be asking himself whether placing Daniel with his father would put Daniel in an intolerable position, rather than whether placing Daniel with his father would subject him to grave risk, given that the judge has said that he's got to take the allegations at their height.
Yes, well, he doesn't consider the grave risk at all.
Yeah.
And of course, it's either or, but then doesn't consider how those particular needs of this child.
And he's got to look at both.
Yes,
Yeah.
and it doesn't import into his decision making at all any analysis of how this particular child with his needs is going to be parented by this father, who's never looked after him full time, and in fact has had very few occasions of overnight contact. We repeatedly asked for a number, my instructions are perhaps 3 or 4 nights overnight, but never alone with the father, and always with the care of his sister and or mother. And you'll recall at the outset of my submissions, we made the point that on separation, the father lived with his sister, his mother, and then more recently with his partner. So all of those issues, very significant issues, we say point to an intolerable situation, and the judge simply failed to detail at all the circumstances which in terms would be on the ground, and the concrete circumstances on the ground in Ireland for this child.
And are you saying at 114 there's reference to protective measures offered, and that's a reference just to the undertaking to push forwards in Ireland?
Yes. Yes. The father would pay for the flights. He'd engage the Irish court. He said the mother, if she returned, could stay with her parents, which the mother didn't accept. But then he goes on to say, I have no doubt that the high bar set by this event is not reached. Well, that's at odds with his findings about the degree of severity and the findings of Dr. Ratnam. So it's, again, the backward look at the test, finding whether the circumstances in Ireland are appropriate, and therefore finds that the Article 13b defence is not met. We say that's the wrong approach, and the discipline was simply not carried out by this judge, despite his numerous references to it. So, in terms of the grounds, I think we've set out, or I've set out in terms the details of ground 1, failure to adopt the RE guidance, failure to understand the concrete arrangements, and failure, and it ignores the situation that Daniel had never lived with the father and never spent overnight alone with him, ignores the very particular issues that this child presented with, and failed to really understand what the father would be able to do in terms of his work environment and his partner should this child be returned to Ireland. It also ignores the very clear warnings of the CAFCAS officer, which he set out at paragraph 49 of her report, and he sets out in his judgment at paragraph 56 as to the particular issues of this child. And the rather clear comment from the CAFCAS officer that the father really underestimates how difficult this child is in the circumstances, where she was shocked. This is a very experienced CAFCAS officer. She was genuinely shocked at his behaviour at age just 7 when she saw him at his home address. And of course the test of no immediate risk is the wrong test in any event, we say. We rely on A, paragraph 83 to 86, and we repeat the intolerability quote from Baroness Hale that the Hague Convention isn't meant in itself to be an instrument of harm. Clearly in this case, with a return in these circumstances, it does become an instrument of harm, where the unknown quantities of a return to Ireland would have a significant and a far-reaching impact on this particular child. Paragraph 88 of Re A, of course, is also the aspect which we rely upon in relation to separation of the child from primary carer. And
sorry, where is that?
that's paragraph 88,
Yes,
page 20.
thank you.
It's also quite clear, and this is my Lord's judgment, of course, it's also clear that the effect of the separation of a child from the taking parent can establish the required grave risk. And my Lord makes reference to a number of other authorities. And of course the quotation from Lady Justice Butler Sloss in C&C, and refusal of a mother would drive a coach and horses through the convention, but then over the page reference to the decision of the former President Sir Mark Posser in S and B, where proper analysis of the circumstances should be undertaken to see whether it meets the threshold of an Article 13B defence. And so my Lord sets out in terms the law in relation to those issues, and at paragraph 94 again makes reference to the Guide to Good Practice. Again, the discipline really set out in Re E, which you refer to at paragraph 93 above. In particular, the quote from Baroness Hale, the last sentence, the clearer the need for protection, the more effective the measures will have to be. In this case, there was no analysis as to what was required for this particular child. And at 96, you again set out the Re-E exercise, but also make reference to falling between two stools, and the reasoning in paragraph 97 that if a judge fails to consider the proper discipline, that there's a risk of falling between two stools, of not considering the risk and then analysing how that would be ameliorated. So we say that that's the arguments in relation to ground 1. Ground 2, 3 and 4 I can take perhaps more shortly. Ground 2 is that the court was wrong to rely on the oral evidence of Miss Demery in circumstances where we had, by the time of final submissions, withdrawn the defence of child's objections. That was the sole basis upon which CAFCAS were instructed to provide a report. The CAFCAS officer was very clear that she was not making a recommendation and had not carried out an assessment. Indeed, she had not spoken to either of the parents. But she did give some flavour to the particular difficulties of this child, having observed him in his own home. But we say, as a point of principle, it's important that the role of CAFCAS is not elevated to effectively a risk assessment in summary proceedings where the Re-E guidance is clear and subject to a court being confident it could dismiss allegations. Allegations are taken at their highest. Ms Demery was also clear that she was not making a recommendation, and in those circumstances we say that the judge was wrong to rely on that evidence at all in terms of risk, but clearly wrong to identify that as a beacon, as he put it in his judgment. Ground 3, wrong to insert the test of immediate harm. I think I've dealt with that, and effectively there's no gloss to be added, and that's effectively what the court did. But it failed to recognise the clear evidence of the CAFCAS officer that the assessment should be done in advance and pending any placement of the child and subject to that assessment, and those were welfare issues.
Where do we get that from, the in advance?
It comes from the written report of the CAFCAS officer, and it's set out in paragraph 56 of the judgment.
Oh, sorry, right.
Forgive me, I just go back to it. Yes, it's page 109.
I mean, it's not. Was she saying in advance, and where she said no adverse? I would recommend a referral. And
we recommend referral. The last sentence: the court may also wish to be assured that there is an alternative interim care arrangement for Daniel pending a welfare investigation.
Yeah, I see. Thank you.
And of course, in terms again, and I repeat, the judge failed to examine the concrete situation on the ground for this child in these circumstances.
So wait a minute. So your submission in respect to this is that first the judge misunderstood the CAFCAS officer's evidence.
Yes.
Because the Kafkas officer was saying that there should be a welfare investigation prior to the child being placed with
Indeed.
the father.
Indeed. Where she had made no risk assessment, there had been no findings, and she accepted no adverse findings. But
The second is that the introduction of the word immediate is not the test.
is not the test, and is effectively a gloss.
And I think the third is you're saying that this led the judge actually not to undertake the Article 13b exercise at all, because he just based it on his assessment of Miss Emery's evidence that there was no immediate risk, and that was that.
Indeed. And that was the beacon that he very significantly relied upon. And so in consequence of that, he failed to examine the risks as a whole and failed to assess and effectively dismiss what he found were very severe allegations by the mother, and found that he could not confidently discount them. And then finally, ground four, again, is perhaps a degree of repetition, but the judge was simply wrong in relation to consideration of separation, where he described it as wandering into the territory of welfare and best interest. And we repeat the REA analysis and your very clear judgment setting out the detail of how a separation can amount to an Article 13b defence. The judge simply failed to consider at all the impact on this child of a separation from his primary carer, but indeed also from his sister, who he's particularly close to and supportive of. And this is a child, of course, who has difficulty in going to school at all, but at times goes to school with his mother's dressing gown as an emotional prop to try and secure his attendance. So, my ladies and my lord, those are my submissions in relation to the 4 grounds of appeal, unless I can assist you further.
No, thank you very much.
Thank you.
Yes, Ms. McKenna.
Lords and ladies, in respect of the application, what I would like to start with is filling in some of the gaps in the presentation on behalf of the appellant in respect of the picture of this child when in Ireland before the proceedings and before the wrongful removal. Certainly there were proceedings in court that had been ongoing for some period, and what the court had before it was a collection of evidence relating to that. And of significance is that Daniel had lived with his father until the age of 5, the point of separation. And on separation, proceedings...
Well, he lived with his father and his mother.
I beg your pardon. Yes, of course. He lived with his father and his mother. So in terms of an established close loving relationship, that's the background to it. He immediately commenced proceedings because of the initial tensions between the parties at the point of separation and the resistance of the mother at that time to contact, which led to the evidence of the orders from the court in Swords being before the court below. And all of the orders there were made by consent. The orders were handwritten and were signed. They are approved by the court in Ireland on each occasion, and they're in your bundle. The second of significance is the 31st of October 2023. It's at page 143 to 145, and that's an extension of the original order, extending contact. Mr. Jarman is right to identify that contact is within the body of the order limited to visiting, what we would call visiting contact, as opposed to staying contact. But there is the usual provision one might find in an order for contact by agreement that there should be such further another as might be agreed. And then that order is extended further on the 27th of February 2024. The order appears at your bundle 148. And this is the order which included the direction that there be a welfare assessment by a court appointed.
Sorry, on page 148.
148 is the order in respect. I don't understand why, my lord, but the balance of the order appears to be missing. But it is the order that the judge had seen in full and is dated the 27th of February 2024. That extends the contact every Wednesday and every Thursday 5:30 till 8 o'clock, and every Sunday 12 o'clock till 7, and alternate Saturdays.
But you were referring, I think, to the item which is numbered 1. The parties on consent agreed to a section 32
Yes,
to be conducted.
that's what.
Yeah.
Perhaps in colloquial terms, we would refer to that in this jurisdiction as a Section 7 report, a welfare and assessment of the children, of the child.
And this is dated?
That's dated the 27th of February 2024.
Thank you.
The evidence as to who was appointed can be found in your bundle at 233. Which is the respondent father's witness statement, paragraph 45, setting out that Anne McCormack of Tulsa, Tulsa being the name given to the social services in Ireland, was to prepare the Section 32 report.
That's in the order too that you just
That's in
shared
the
us.
order, so there's confirmation, but it didn't take place because the mother had left Ireland wrongfully with Daniel. And he gave, in paragraph 45, without it being asked to by the hearing judge, an agreement to happily engage with Miss McCormack or any other social worker in Ireland, should that be necessary. The dates of those consent orders, and I do emphasise consent, because it's relevant to the issue of intolerability, the point about separation, and the complaint that the appellant makes that there has been seeking to impress upon this court that there's been no permissive order of the Irish court for staying contact. The court in Ireland repeatedly sanctioned and approved agreements that there should be unsupervised contact, with the provision that the parties could agree otherwise. And that is precisely what they did. They did agree otherwise. Over and above those provisions, they agreed that there should be, at the mother's instigation, staying contact. And we know that this is the case because it's revealed in the text messages that the father disclosed to the court below. And I note he disclosed months' worth of text messages rather than cherry picking. So if you turn to page 380 of your bundle, you can see that these are, I beg one. Yes, 380. You'll see that these are messages between the parents, dated the 29th of March 2024, so very shortly after that last order I had taken you to at 148. And the mother says, in relaxed terms, hey, don't suppose you'd like the kids for a sleepover this weekend or next weekend, if you can. They say they wouldn't mind sleeping at the father's partner's home, whatever makes them happy. So far so good this week. And the father responds in very relaxed terms, yes, next week I'm planning on taking them away. They asked me last night, so I'll look up places. If I can ask your indulgence, I'm going to continue with this page in the next, for this and other reasons. But further down, you will see that the mother writes to the father, Grand, will you do this passport with me next week, as well as it's just Daniel's I need to sign for? And she's, at this point, needing his signature on a passport application for Daniel. And the father returns with, I'm going to double check if we are allowed to be there in the same time, just to be on the safe side. And I draw your attention to that because that's evidence of the father seeking to comply with the protective measures which were in place, that they not come into contact with one another, and he's wanting to double check and not walk into error by accident. Over the page at 381, The mother replies to that concern, yes, it's at the Garda station. Will you signing a form that it's your lords and ladyships can read that. I won't say anything to the kids. You can tell them. They will be delighted. Don't forget to drop off his jumper, off his tracksuit up at some stage. Can you keep them till Sunday until 8:30 if you don't mind? So very clearly, ordinary arrangements for a stayover about which the mother says the children will be delighted. And then the continuation of the conversation, it continues to be very relaxed and banterful because the father says, yes, I'll keep them until 8:30, no problem. And the mother has a response where she reflects that she's going to have more time in bed. That's the first indication that we have that there's contact way beyond the agreed orders. But if you look at page 384, it's not a one-off or even a two-off, as the mother, through this appeal, would have you think. You can see on 384 messages continuing. This time we've reached the 6th of April 2024. And in the middle of the page, there's a discussion about food for the children, and the mother says in the middle of the page, hey, Daniel is okay, don't want to be... She's inquiring about Daniel because he is with his father, don't want to be bothering you on your holiday. Just checking in to see he's okay. I've been texting Rachel. So it's not just a one-off overnight, it's a holiday arrangement. And here's the evidence for it. And if you go down that page, there's a discussion. The mother's talking to the father about co-parenting issues to do with looking after a skin condition for one of the children, washing powder. And the father, on the next page at 385, replies, fully compliant and with that important issue of welfare. And the mother finishes off this page with, oh, they're having a ball, thank you to you and your partner, it means a lot. So in April of 2024, that's the context of the additional and very relaxed contact and staying arrangements that are flowing between these two children and our client, the father to this appeal. And those are text messages that were before the court below, and those are text messages that are mentioned within the judgment, albeit in passing. But they were the judge was taken to them in the detail, and that afforded him the background information about the relationship between the parents and the confidence with which the mother had about leaving Daniel in the care of his father. It's in the judgment at page 103, paragraph 26, and he's very clear. He says there, the parties availed themselves of the provision for additional contact. He makes reference to the text messages, and he's very clear at the conclusion of that. I'm not finding facts at this hearing, but reading those messages leaves me with the impression that at that stage, the parties had a comparatively good relationship and that overnight contact did not appear to be in any way extraordinary. The other picture dealing with the situation in Ireland that I invite this court to look at this point to correct the picture is at page 377. And what I'm taking the court to here, I'm afraid it's sideways in your bundle, but it's a school report for Daniel, the most recent two school reports. On page 377, we have the report ending the summer term 2023, so the first year post-separation, but once contact has been resumed.
Sorry, can you give me the page number again?
Yes, 377,
Thank you.
and this is June 2023. And in the box marked comment.
So where are we? Are we in Ireland or are we...
Ireland.
Yes, exactly. Thank you.
Around this year.
It's Daniel.
Daniel.
I beg your pardon, thank you. He has definitely put a smile on my face with his witty sense of humour. He has a fantastic progress, both socially and academically. He should be very proud of himself. I wish him all the best in senior infants. And if you and you could see the attendance is good. Over the page, a year later, almost to the day, the 21st of June 2024. Attendance is a very similar ratio. There's reference on the left of the page. While Daniel has made progress in many ways throughout the year, he's still struggling socially and emotionally. And of course, the school are giving him the in-class support. And then under comments, Daniel shows great imagination, has made good progress in many areas. Keep up the good work. It's been a pleasure to teach. It's been a pleasure to teach. Daniel left their school at the end of that summer term on the 21st of June, expecting to return in September. But of course we know, and it's accepted, that there was the wrongful removal. But it is also known and accepted that in the weeks prior to the end of that term, when the appellant's mental health deteriorated and she sought to place Daniel with someone whilst she received treatment, her immediate port of call was the father. She arranged contact between Daniel and his father on, we know the last date they saw one another before removal was the 27th of June, so after the end of the school term. All of those elements are important because when we compare the evidence that was before the court below, see page 203, it's a letter from the current school for Daniel, dated April 2025. Dear Mr. Bone, Mr. Bone is the solicitor for the appellant. And we know that he was only admitted on the 13th of November 2024, that's in the second paragraph. So he'd missed school entirely since June. He was only able to attend for an hour. And even at this point, the point of the letter was only attending for 2 hours. There is a marked contrast in the presentation, in the evidence that we have, that the court had about the presentation of Daniel in Ireland, the free flow of time spent with his father, and the loss of school, place, and the certainty that that afforded him, and his presentation by the time we get to April of the following year. And at that point, I want to draw your attention to an important feature of the judge's overview of the evidence, and this was a factor that we submit formulated his ability to look at, in overview, all of the matters relating to Daniel. And he identified, at page 39 of his page 105 of his judgment, paragraph 39. This is the culmination of a section of the judgment setting out events since removal. And the paragraphs 32 up to 39 set out the unsettled and unstable circumstances in which Daniel had been wrongfully removed, living with his mother, and moved from pillar to post, quite literally, 5 different addresses. And that was by the end of March. That's relevant for this reason. The application of the appellant is that there should be new permission granted for the adducement of further evidence from Dr. Randall. And a significant detail of the Dr. Randall report, it's on page 80 of your bundle, is that the date of Dr. Randall's involvement with Daniel was a visit to the school made on the 21st of March, 2025. By which time, as I've explained, he'd had 5 different addresses. He'd had a significant period of absence from school, and we know a cessation of direct contact with his father for about 9 months. In addition to that, he had, in the preceding days, and this is confirmed through the report of Miss Demery from Kafkas, the following features of his life. Firstly, his local English allocated social worker confirmed to Miss Demery that on the 13th of March, that's the 13th of March 2025, she, the social worker, was aware of talk that Daniel would be returning to Ireland with his father. On the 17th of March, so just a few days later, we know that the mother sent to the father, at page 357, you will see the photograph, a photograph of the bags that Daniel had packed ready for his return to Ireland. 357 and 358. I take you to both pages because on 57 the photograph is not downloaded, but on 58 it is, and 57 gives you the date, 356, the 17th of March. On the 18th of March, so just the next day, if you turn to page 360, you'll see the mother is writing to the father by text message at 6:32 in the morning. Okay, relax, I just want him to be happy. I told you if he still wants to go back by the end of the week, I'll contact the solicitor and see what we can do. He goes through these emotions and it's normal. Leave it with me. I'll get him to ring you after school. Now, unbeknownst
Sorry, which date was that?
This is the 18th of March.
Thank you.
And the date we know is from the page before. So the 17th she sends the photographs. The 18th, mother's confirming to the father that she, the mother, the appellant, fully contemplates circumstances where Daniel would return to Ireland without her. And I say without her because if you look to page 366, you will find still the chain of the same day, so we're still on the 18th of March. She says, book a flight for Friday.
Sorry, page 3 what?
66.
Thank you.
366. The mother says to the father, book a flight for Friday to take Daniel back to Ireland. I'm not putting the kids through this again. You have won, you've got what you want. He will have to fly Aer Lingus. This, please note, is at 14:03. It's a continuation of text conversation. And the father's instinctive response is recorded there. He gives the mother's name. It's just not that easy. I'm after fighting for 9 months now to get where we are. So I'm going to email my solicitor what you sent and see what is going on. So he's fully compliant with the process. He's not wanting to simply take matters into his own hands. But what he doesn't know, and what Miss Demery doesn't know, he doesn't know Miss Demery is actually at the property when the mother is sending this message. And Miss Demery, who was at the property because she confirmed on inquiry that she arrived at the mother's home at about 1:30, the same day, the 18th of March, that while she was endeavouring to speak with Daniel, the mother was busy texting it from another room to the father, instructing him to collect. The conversation continues on 367. The father's saying, my solicitor's not back until tomorrow, and she says, that's fine. I've contacted mine to let her know Daniel can go back to Ireland on Friday into your care and social services will take over. You can read the full message on the next page. And the father says, I'll gladly go over on Friday and take Daniel, but I can tell you now it's not going to be that easy, especially that everything that's happened, and we will see what they say tomorrow. So he's deferring until he gets some legal advice about what the mother has been saying to him. All of this may seem the relevance of all of this is that clearly in the appellant's mind was the real outcome that the children and that Daniel from her would be separated and have different futures, whether in the short, medium or long term. It was something that she was seeking to achieve. And in addition to that, she withdrew that encouragement because she received legal advice. Legal advice, in fact, that she shared with the father, but that's it. Going back to the reason why I took the court to these text exchanges is because the 18th of March, when Daniel has had all of these experiences, now for a sustained period, at least from the 13th of March, believing he was going home, meets with Dr. Randall. I beg your pardon, there's another injection of this, which is that the following day, the 19th of March, the mother had been supported by a YMCA worker who attended at the home to say goodbye and confirmed to Miss Demery, as Miss Demery has recorded it in her report, the YMCA worker left the property believing Daniel was leaving on Friday the 21st. So on any view, Daniel's position is a confused one if you're 7 years old. Add to that the injection of Dr. Randall turning up at school 2 days later, on the 21st. So the context of Dr. Randall's report is really very important. Mr. Jarman elevated it too high to say that he, Dr. Randall, provides the only objective and independent evidence about Daniel's presentation. In fact, it isn't known what Dr. Randall knew about Daniel, but what the court can be certain of is he did not know what had been happening in Daniel's life in the days immediately leading up to the only occasion on which he met him. And to the extent that he gives information to the readers of his report that Daniel appeared dysregulated when his mother was leaving, that's an experience of the school on other days. But Dr. Randall adds to that with there are many minor things that might cause Daniel to flare up, not just the mother leaving him at school. So to the extent the court might choose to admit the evidence, we have to look at it in this way. Is it relevant? It's relevant to the extent that it's another piece of information about Daniel. Would it have a material impact on the outcome of the earlier judge's decision? Well, not in the context of Dr. Randall not knowing the social circumstances of Daniel. He knew clearly that the parties were in court about something, but he certainly didn't know the emotional turmoil that had been imposed on Daniel by the mother giving Daniel the clear impression and the professional network around the family that Daniel was going back and inviting the father to collect Daniel and then withdrawing that. That's the second time in which that had happened because, of course, the judge in his judgment had made reference to the invitation freely given by the mother in text messages in February of 2025, inviting the father to come to England, to the town where they are, to take Daniel and stay in a hotel for the weekend. And then when she had spoken with her solicitor, that invitation had been withdrawn. That, we say, is not a fair way to approach the litigation, but it can be explained by the mother wanting to present in the clearest possible way to a court when running an Article 13b defence. Just to finish off with the text messages, and then I'll leave them if I may, I would invite the court to look at page 391. This is still the text exchange from Christmas 2025. So this one is dated the 20th of February 2025. And it's in the context
for... Sorry. Could you give me the date again?
Yes, the 20th of February 2025.
Thank you.
So this year. Below the first punch hole, the mother again writing, she's talking about she's assuring the father she's not trying to evade the Kafkas assessment. I'm not trying to avoid the assessment whatsoever. I'd gladly let it happen, but I'm not going to stress my kids travelling that amount of time. As I said, Daniel made a decision that if Daniel made a decision that he wanted to go back to Dublin, I would get in touch and tell you to come and get him. I wouldn't stress them out, you know. And then she goes on, and this is significant in the context of the Article 13b. And the solicitor said they will hold on to my passport longer, which I don't want, as Andrea, and then two names are given, the names of the mother's sisters, are due to have babies, and I'd like to be able to go over and see them, so I'll see what happens and let you know. The relevance of that is the mother herself is contemplating a return to Ireland, albeit for a visit, but a return to Ireland. And that's information and evidence in the judge's mind when looking at the matter in overview. Those are the matters that I wanted to take you to in respect of the text messages. The judge below very clearly was right to conclude he was not conducting a welfare analysis. The nature of the proceedings are summary, and he has at all times to use his best skills to navigate the evidence that he had before him. But in formulating his judgment, this court will, of course, I hope, bear in mind that he did hear evidence. He heard evidence from Dr. Ratnam. He heard evidence from Miss Demery, who was the only person with first-hand experience of the subject child. And there were difficulties with that because, of course, it was within the process of cross-examination that Miss Demery learned about the mother's communications with the father during the currency of her visit to the child. Well, I commend to this court the detail and attention that the judge gave to the evidence. It is a significant and carefully constructed judgment to the extent that he has not just summarised everything, but given detail and attention to it. The question your lordship asked Mr. Jarman was was there anywhere within the judgment itemised or acknowledged the detail of the harm that the mother alleged amounted to the grave risk. And I invite you to look at page 100, because he does very powerfully in paragraph 13.
Sorry, page
100 of the judge of your bundle, page 100 of and paragraph 13.
Sorry, what are we looking at the judgment?
Yes.
Yes.
Okay.
Sorry, it's paragraph.
Yeah, no, it's all right. Anyway. Yes.
And he does. You know from the skeleton argument of the appellant that I've counted that there are enumerated data letters. There are 18 allegations, more or less encapsulated in paragraph 13 of the judgment, without missing any of the detail of the serious nature of the allegations that the mother has made, acknowledging that they are all denied by the father.
Yes.
And identifying that he relates and reminds himself of Practice Direction 12J and the serious consequences for children who live with domestic violence. It isn't incumbent on the court to, within a judgment, spell out chapter and verse the risks to children exposed in those circumstances, but he has rightly drawn the reader's attention to what he had in mind and the level of detail and scale and scope of the allegations. He has also ensured that he has summarised the history, criminal history of both parties. And those are in the subsequent paragraphs 15 onwards through to paragraph 21. when he switches in terms of the narrative of background to informing the reader that there were, in respect of both parties, as against one another, protection or safety orders flowing. And that's the foundation that gives him, later on in the judgment, the confidence to say that the protective measures in Ireland are something that he has regard to, and I say, rightly places confidence in. So the concerns set out in the appellant's grounds relate to criticism of the judge in reliance on information and views offered by Miss Demery. But it is abundantly clear from the evidence quoted variously of Miss Demery and from her report that she is not making recommendations. She was not invited to, directed to, and she positively tells the court that's not what she's doing. She is quite reasonably asked questions and gives a view, makes suggestions, but doesn't require. And although the appellant, through Mr Jarman, has taken this court to the aspect of her report which suggested that the court, considering the application for the return order, might want to understand if there was scope in Ireland for interim or alternative interim arrangements for Daniel. That wasn't something that she pressed or held to when she was delivering her oral evidence to the court and questioned about it. What she opined or suggested that there needed to be a welfare report would be prudent in any case where there were going to be contested proceedings if a child was returned. But in this case, there already were contested proceedings in respect of the children in Ireland that had been afoot for over 18 months. And the reason that they had been suspended and the welfare assessment not engaged with was because of the mother evading the attention of Miss McCormack and the attention of the Irish court and leaving Ireland completely. But there was never in Ireland any application by the mother for her prohibition on contact to Daniel or a restriction other than that the parties might not come into contact with each other for a process of handover. And so that is the height in terms of the risk of Daniel in his father's care from the mother's perspective. She her case morphed to the extent that, beg your pardon, I withdraw that word, her case altered over time in that she presented to the court at the final hearing that it would be intolerable for Daniel to be separated from her on whatever basis, yet the foundation evidence was that before the court, which I have taken this court to, that it was well within her contemplation, and indeed at times her invitation for Daniel to be collected and removed from her, knowing that the consequences would be the end of proceedings here and a return to proceedings in Ireland. That she had always engaged with until her departure from Ireland and had always had representation in a point made by the judge in his judgment twice. They had both parties in Ireland had access to publicly funded legal representation. Now, of course, the consequence of the return order, if this appeal is granted, is that that would not be the situation that the respondent father would find himself in terms of trying to address child arrangements proceedings for Daniel in this jurisdiction. In respect of the may I take the court in particular, now specifically to the grounds relied on?
Well, what the judge sets out in paragraph 94 of his judgment
Yes.
is the matters relied on by the mother in respect of her case under Article 13b. So the father's behaviour generally, and then the C, D and E.
Yes.
And if you look at paragraph 95, the judge there says that these are of the very highest order. Is that the judge's assessment of them, or is that his reciting the submission made to him?
From the outset, I think the judge had understood that neither party sought to diminish the seriousness of the allegations.
So
I did not suggest to him that they were of the highest order, but he came to the view himself that they were of the highest order.
right. So you're sorry, I lost the paragraph.
It was paragraph 13, which was the one listing the elements of the allegations.
Yeah, no. Wait, sorry. Hold on a second. I'll get that in there. Paragraph 94. So, paragraph 95, you agree with Mr. Jarman that when in the second sentence, that is the judge's assessment of those particular allegations. They are of the highest order, very highest order.
I'm bound to accept that's the judge's conclusion in respect of that.
So then he addresses mental health. Then he addresses the child's needs. And the judge says in the third sentence, I struggle with the submission as to the nature of the case, as to the effect on the child of return to Ireland is, I mean, I know that the words he used are exacerbated by his own needs, but in other words, that his own particular vulnerabilities and needs mean that there are risks to him of returning. And he says at the end, and I think he's probably right about this, that this submission may be intertwined with the submission that it's intolerable for the child to be separated. He says removed from, but separated from. He then, in paragraph 98, says the submission about separation seems to wander into the territory of welfare. What do you say about that sentence?
It's inevitable that when examining the issue of whether or not the separation is intolerable, that there's an injection of analysis as to the impact, therefore the welfare of the child concerned. What will happen to the child if separation is forced upon the situation?
But what he seems to be using that sentence is to discount this issue and think that it's not an issue that he should or needs to address, because it's wandering into welfare.
But he goes on to say, and I think it's an important sentence at the end of that paragraph, I'm not deciding where Daniel will live in the future. In terms of, I think the point my Lord is making, is the judge dodging the issue? Is he seeking to put it to one side and move on?
Well, where does he come back to the issue of separation?
He comes back at paragraph 113, when he says that separation of Daniel from Mum and Rachel is far from ideal.
Right.
Were I applying a welfare standard, I would probably come to a different conclusion. And then he goes on to say, that which I've explained, when Mum was incapacitated due to being hospitalised, she looked to the father to care for Daniel.
Right. Thank you.
And I accept he acknowledges different circumstances, but I do not think that placing Daniel with his father temporarily will put Daniel in an intolerable position. So he does return to it.
But what does he mean by temporarily?
The use of the word, for the purpose of his decision, he is putting Daniel in his father's care because the mother has told the court and the court accepts she will not go back. But what I take you back to paragraph 98, he acknowledges he's not determining the long-term future of Daniel. There are equivalent child arrangements proceedings in Ireland, an assessment that will need to take place. And for all he knows, he does not know, the mother may make her own application for leave to remove from Ireland back to England. And to extend that point, my lord, paragraph 99, which covers the issue E, intolerability of Daniel being separated from Rachel. C, D, and E are rather intertwined. The manner in which he's dealt with the issue of separation from Rachel is very similar, and it's encapsulated in the way he's dealt with it in terms of the mother. The evidence, he's right to say, points to submission that Daniel and Rachel have a very close bond, but that's the extent of the evidence that he had. He wasn't presented with any evidence of that was going to persuade him of an intolerable situation for Daniel. And in any event, if we turn back to 113, what he acknowledges is that she, the mother, turned to the father to look after Daniel, but she, the mother, had turned to others to look after Rachel for the same period of her incarceration. So the mother herself had separated the children. I accept the judge doesn't spell this out, but it was in the evidence before him. The mother herself, through the text messages that I'd taken the court to, and which the judge had seen, had envisaged the separation of Daniel from Rachel by inviting the father to collect. I think that perhaps what the court might see as the biggest area of concern for this judgment is whether or not there was an excessive reliance on two beacons being the view of Miss Demery and the fact that the mother would not return. And in respect of beacons, there are two features of the evidence. They're important features. He's attributed an adjective to them. But standing back from the judgment as a whole, which is careful, which was considered and written and provided to the parties after some days of consideration, it is clear that there are, the judgment is multifaceted. Every aspect has been properly analysed. Those are two standout features. But I would submit that the way he has drafted the judgment does not justify the complaint that he has been misled by Kafkas into one particular view, and certainly not misled by the mother. He accepted her statement at face value for very clear reasons that she was not going to return. And that was in accordance with her behaviour leading up to the hearing in any event, and the manner in which she envisaged a life in England but without Daniel. The paragraph 114, beg your pardon, it only is 114. I must confront, because of course it is here that the judge, I would submit, is applying the RE test. He's looking at the section Article 13B defence. He's looking at whether protective measures are sufficient or likely to be sufficient, whether the defence is met, and on one view it's unfortunate that in a single sentence that appears to be the manner in which he's addressed that issue. So
you're saying that's his re-analysis?
No, I'm saying that's where he's concluded his re-analysis in a short sentence, but that in fact, standing back from the judgment, his analysis is greater than that. It's unfortunate, I say, that it appears to be encapsulated in a single sentence, and I say that's unfair to the judgment.
Well, where does the judge analyse whether, if true, the allegations would establish the Article 13B grounds?
In terms, that does not appear within this judgment. But I say that it can be read into the judgment when the court reads paragraph 111. The judge is there in his decision discussing Miss Demery's attention to the allegations, his own attention to the allegations, acknowledgement that the mother will stay in England if Daniel is returned, acknowledging that therefore the aspect of the mother's mental health which could have given rise to the grave risk of harm to Daniel would not stand. But I say it goes further than that. When you look at paragraph 13, which was the list of range of allegations, scope of the allegations that the mother made, there are two things. First, missing from the mother's allegations is any suggestion that harm has been caused directly to Daniel. And secondly, is the judge's acknowledgement that he had in mind Practice Direction 12J in respect of the impact of domestic abuse on children.
Right. So when the judge refers in paragraph 114 to the protective measures which he seems to be taking in mind when addressing Article 13b, what protective measures is he talking about?
If you turn back to page 119, paragraph 101, the protective measures are set out. He's reminding himself of what is proposed on behalf of the father. He's reminding himself at 102 that in addition, the father gave the assurance through myself and Miss Watts that he would immediately return to the court in Ireland to set in train the process of the welfare inquiry.
Insofar as 101 is concerned, speaking for myself, I don't immediately see how those address the risk created, if this is the right way to look at it, or the right conclusion, created by the allegations made by the mother of A, the child going to live with the father, and B, being separated from the mother. Those simply are the arrangements that would be undertaken largely to enable the return to take place. I don't see that they address the risk. Do you say they do?
I say that. Can we look a little further down at page 106?
But before you do that, I'm sorry, paragraph 101, sorry to interrupt you, but should it not be read with 102, the additional undertaking that the father would go immediately to the court in Ireland and set in train process of the welfare inquiry there?
Yes, and also 106.
Thank you. Sorry to have interrupted.
No, it's all right. First of all, in respect to 101, how do those address the risk, if there is such a risk, of the child living with the father?
When you look at paragraph 106, what the judge was reminded of and accepted was that the measures that were proposed on the father's behalf had been in place in Ireland and had been working effectively. She, that's me, also reminded me I must assume that there are adequate and effective measures of protection in Ireland, given the fact that I have seen that both parties have been protected by court orders in Ireland and that the family have a benefit of a social worker, etc. What is relevant from the chronology of the case is that once protective measures were put in place, and you can see that from, and this is in Ireland, in the children proceedings, the orders were put in place on the 9th of June 2023. The mother offers no complaint about the father's conduct in terms of breach of that post that date. So the judge is I say, it's right to read into the judgment. The judge is saying the orders were in place, the orders were working, the orders will work.
But work in what sense? I don't understand how work in what sense.
In protecting from the risk of future harm.
Well, how? How protecting from the risk of harm if the child is living with the father?
There is no. There is the impact of domestic violence, which is acknowledged by the judge, but there is no allegation in this case, and this is where it's different from your own judgment, my lord, is that there is no allegation that the father has abused the child directly. That's important because the risk to the child is the exposure to domestic violence, domestic abuse. The reality is that the mother is not returning to Ireland, but that in any event, protective measures have a history of working in this case.
You might say the risk to the child is of living with a father against whom these very serious allegations of the highest order are made without any assessment or without any investigation as to their truth. Now, you might say that's the risk. That's why I kept emphasising living with the father. And what I'm trying to analyse is whether the judge was assuming he was undertaking the re-exercise, that he was right to say, bearing in mind the protective measures offered, and assuming he meant by that they would sufficiently ameliorate the grave risk so that this case didn't come within Article 13b. So I'm giving him the benefit of the doubt in that respect. And what I'm trying to analyse with your assistance is how these protective measures would actually address the risk. So we've dealt with 101 and 106. If we look at 102, the judge there refers to the process of a welfare inquiry. How is the process of a welfare inquiry going to address the risk, you say?
The fact of a welfare inquiry, if we go back to why it was necessary, Miss Demery wanted it to ensure that Daniel's needs were being met in the care of his father. The Irish court, to an extent, had already conducted its own welfare assessment in that it had ratified consent orders for direct contact with the children without supervision for over a year, and in the knowledge that the mother and father had agreed additional, and we now know staying contacts, we can evidence that. So the welfare inquiry needs to ascertain whether the needs of Daniel are being protected or met in the short, medium and long term, and what is it at that point on a return order that the mother may be seeking, or is it that she's not seeking anything? The mother did not declare her intentions other than not returning.
When we look at paragraph 56 of the judgment, where the judge refers to Miss Demery's evidence, and the last sentence of paragraph 49 of her report, the court may also wish to be assured that there are alternative interim care arrangements for the child pending the welfare. What did Miss Demery mean by that?
Miss Demery did not expand on the written, that aspect of her report to say, and she did not repeat that need in the process of her oral evidence. But
I mean, you've heard Mr. Jarman's submission that his submission is that Miss Demery was there saying that there needed to be a welfare investigation prior to the child being placed with the father.
Well, she uses the word may. She's not a recommendation that it's an imperative.
Don't worry, I understand that.
Yeah.
But do you?
I understand. I say that she did not stand by that, even as a suggestion. In fact, when you look at the evidence that is, I think, recorded within the judgment, certainly she envisaged that the child would go to the father, knowing that the child hadn't lived with the father since he was 5, so some 2 years, and may not know the father's partner well. Miss Demery not at that point alive to the detail of the communications between the parties, wherein the mother praises the partner and says the children are having a great time, etc. So there is a limit to Miss Demery's recommendation, if it's, and I don't put it as high as it's a recommendation, it's a suggestion,
Yes.
that she doesn't pursue. And in any event, the foundation evidence didn't support that on the mother's own communications to the father. So in terms of an interim placement, in colloquial terms, should there be a foster placement or an alternative kinship placement with a member of the family, Miss Demery, you'll recall, had identified that it could not be with the mother's family because of mental health problems in that family, and that the father was the only avenue or place of care that she could suggest. And in giving that evidence, she did not repeat significantly, I say, the suggestion in her written report that perhaps the English court needed to contact, through judicial contacts, liaison, whatever, the authorities in Ireland to ensure that there were measures in place for receipt of the child. That wasn't something that she was suggesting to the court. In fact, it was very direct, transfer to the father by way of collection, given that the mother was refusing to go.
Sorry, I think we took you off. You were going through the grounds.
In terms of the second ground, which is this issue about the whether the judge was right to rely on the evidence of Kafka's. As I've been saying, that the evidence of Kafka's was very clear that there wasn't a recommendation being made. I think the greater, I have to accept that the greater difficulty, from my perspective, in respect of the evidence of Miss Demery, is whether or not the judge has rightly or wrongly attached too much weight to the use of the word immediate. And this is moving on to ground 3 as to whether or not he has, through his judgment, imposed a gloss on the convention that to the defence that wasn't there. And in respect of that, we've dealt with, Miss Watson and I have addressed this in our skeleton argument, which I've mislaid at the moment.
Yes.
And we say that it's in respect of adding words.
Sorry, which paragraph are you at?
The relevant part of the skeleton is at paragraph 72.
Thank you.
But in there,
Yes.
we draw, in 73, we draw attention to the judgment in Re E, which identifies that Article 13b is forward-looking, looking to the future, looking to the situation as it would be if the child were returned to his or her home country. The question for the judge on my application for the return order was what would be the circumstances for Daniel on a return. And that involves the court looking at the short, medium term and the long term. It's so whether he had used the words short, medium and long is immaterial, because what he has to assess is what will happen to Daniel if I make a return order. Where will he go? Who will he be cared for in the immediate period? What will be the next step? And the next step, this judge knew, would be that the proceedings which were already afoot in Ireland would be triggered again by the father's application to secure Daniel's circumstances in Ireland and a welfare assessment. And so I don't I reject the submission on this appeal that it was an impermissible gloss. It was a necessity for the trial judge to understand what would happen on the ground, and that involves what's going to happen today, tomorrow and the next week. And so it's not an extension of the convention
But
in the way complained of.
sorry to interrupt, but if the judge, as he seems to do at first reading, only focused on the immediate future, hasn't he left out of account part of what you accept his analysis should have included, i.e. medium and long term?
Well, to the extent that he did, my lady, he made reference within the judgment that he was, and acknowledging rightly so, that he was not determining where Daniel would live, because he is not the judge charged with the welfare decision making for the long term for Daniel. He's determining whether a child whose habitual residence is known to be Ireland, who was known and accepted wrongfully removed from Ireland, and in paragraph 98 he says, I am not deciding where Daniel will live in the future.
But deciding where Daniel will live in the future is not the same as considering what might happen were the court's decision to be that Daniel should live with his father. two different exercises.
Well, the judge in England is not deciding that Daniel should live with his father. The judge is making the decision that Daniel should return to Ireland, looking to the immediate future, which would be living with his father, subject thereafter to decision making in the home country of the child. It would have been wrong for this judge to say, and long term, for example, investigate or imagine the circumstances of Daniel at the age of 7, 8, 9 and 10 living at a distance from his mother, because this judge would not know, and it would be wrong for him to make those decisions. Those are our only decisions. It's the purpose of the convention on this aspect, to return the child to his country of habitual residence so that those welfare decisions can be made there. Predicting what the mother might do is limited only that he accepts on the evidence before him at this time that she was not going to go back to Ireland with Daniel. What she did thereafter, he's not assessing.
But if it's not the judge's job to decide where Daniel's going to live, how can the judge do what you acknowledge he should have done, which is to think about the medium and the long term as well as the immediate future?
Well, if we, looking at the extract of Re-Eat that we've set out at paragraph 73, what the court is bound to be looking at is that acknowledging that where the child, any child, is going to be returned to a home country, it may not be to the person, it may be to an institution or other body, and of course it may be so that the person has the right to demand it, but those are not issues for the judge in England. More importantly, the situation which the child will face on return depends crucially on the protective measures, etc. And of course, that's a separate issue. But you're asking, if I've understood correctly, why is the judge not, my lady, why is the judge not assessing the long-term impact on Daniel of
I'm
return?
just trying to understand your submission, because as I understood what you were saying the judge doesn't just look at the immediate future, but the medium and the long-term future. And my question is, well, if the judge only focuses on the immediate future, how does he do the two things that you appear to have acknowledged he should be doing?
Well, that's the point at which this judge is not in a position to understand the long-term consequences.
Right, okay.
Because, of course, the circumstances will materially be different if a return order is made and put into effect. And jurisdiction sparks up again in the country where the child is.
Well, the passage you quoted from Re leaves out the last sentence of that paragraph, when it's recorded Mr Turner, counsel then acting, accepts that if the risk is serious enough to fall within Article 13b, the court is not only concerned with the child's immediate future, because the need for effective protection may persist. So the court does have to look beyond the immediate, because what the court is looking at is the effect of its order. And that's why I was focusing on in part on what Mr Emery was saying about the need for a welfare assessment, the need for possible alternative interim care arrangements. Because one thing the judge might have to have in mind is what happens if the Irish authorities decide that the child definitely should not be placed with the father. What happens then? Because the judge seems to have placed huge confidence on the fact that a welfare assessment of unknown duration will take place.
Well,
But we don't have no idea, as I say, how long it will take place, nor what the outcome of it will be.
No. But he's not looking into an abyss, my lord. He knows that the court has already ordered a welfare assessment, and it will take place if the child is made accessible by the person charged with that task. The child had been removed by the mother, so it hadn't taken place. In terms of wandering into the territory of the longer term, he has his expressed confidence in the agencies, judicial, police and social service and education agencies in Ireland, within his judgment. And it's the point of handover, my lord. The best the English court can do is look, will there be protective measures that are effective? he has the history of protective measures being effective, and in passing I say that they've lapsed by a fluxion of time and neither party had sought to renew them. That was in April of last year. And he has the confidence that there'll be a welfare assessment. Beyond that,
yes.
there's a limit to...
But are you saying the protective measures of the Irish authorities will remove the child immediately from the father, as that's what is thought to be necessary? Is that a protective measure?
Yes, it certainly is. If the Tulsa, the social services of Ireland, take the view that the child is sufficiently at risk of harm in the father's care, then appropriate steps could be taken in the courts in Ireland.
And this is a child who needs stability.
And hasn't had any since he was wrongfully removed.
But would that create stability?
But he's generating stability by putting the child back into circumstances where he only ever had one home, only ever had one school, only ever had contact with both his parents. The difference being at this point is that the mother has chosen to be in a different jurisdiction. And so it would be not a return to the unknown. He would be, the court knew, able to return to his school placement. They were expecting him. Able to return to the 2-to-1 carers that he had in the school. Already had an allocated social worker nominated for this case. And indeed a judge.
But the home would be different because the father is living somewhere else from where he lived before.
That is a difference. But the evidence before the court was that that father's partner, of whom the mother approved, were well known to the children through the process of staying there in the past. Something that the mother sought to minimise in these summary proceedings, but
was in the texts.
Yeah. Yes.
Just while it's in my mind, if we were to conclude that the judge has fallen into error and his decision is unsustainable, what is your submission as to what we should then do? Please.
In those circumstances, I would invite the court to remit for rehearing. The worst outcome for Daniel would be for you to impose a decision, I submit, impose your own decision of dismissing my client's application, as it were, in the sense that his father is living in a different jurisdiction and has no access to publicly funded representation from that distance. His only resource to access to his son would be through the English court. The outcome, if you are persuaded that the judge has fallen into error, is by way of a rehearing before a different judge.
So I don't entirely follow the fact that what might happen in future proceedings. I'm not sure that's a relevant factor for the purposes of Article 13b. So why does it need to be? It's a paper exercise. We have all the papers.
Yes.
Why do we need to remit it rather than make the decision ourselves?
There's the decision in respect of Dr. Randall in terms of the additional evidence. If that were to be admitted, we are denied the opportunity to understand the basis of that evidence, if that was to be influential on your decision making. We have no knowledge of what material he saw, no opportunity to question him, and his evidence would be not expert evidence to the court, as he's not appointed in those circumstances, the court having very specifically refused the mother's application for a single joint expert at an earlier hearing. This court, if you were to consider that the judge had fallen into error, of course can reevaluate the evidence and make the same decision again, but for different or additional reasons. I'm keen to ensure from my client's perspective that these summary proceedings are dealt with as efficiently and as speedily as possible. He having made the application in the autumn of last year, and we're now heading to the end of the summer term.
Thank you.
Can I turn my back to speak
Yes,
with Miss
of course.
Watts for a moment? I just add to one
Yes.
aspect of an earlier submission.
Yes.
That Ms Watts has rightly reminded you. I was listing the issues of instability in Daniel's life,
Yes.
in contrasting that with what he had achieved in Ireland. She reminds me that he has already in England been enrolled in 2 schools. There was one in September, and it's referenced in the judgment that there was a move. And all we know from the letter to Mr Byrne is that there was a significant period of the spring term that he wasn't in attendance. He'd only attended for 5 weeks. And so we say that that emphasises the instability of the life here, and we invite you to hold that in mind when considering the best outcome for this appeal.
Thank you. Thank you very much. Yes, Mr. Chairman.
Well, I see the time. I don't anticipate being very long, so I endeavour to finish very shortly, perhaps 5-10 minutes. My Lord,
Okay,
my
over 1 o'clock.
learned friends,
Yeah. Okay. Yeah. Yes. Thank,
thank you. My learned friends just made the point is that paragraph 32 of the judgment, where the judge refers to starting school in September 24 and then moving in November. And of course, you've been directed to the Irish school reports in June of 23 and June of 24. Neither of those reports makes any reference to the child being supported on a 2-to-1 basis. And in my submission, they are very rose-pictured synopsises of the child's presentation at school. They make no reference really to his particular issues. They do make reference to a high degree of absenteeism, even in the Irish school, both in 2023 and 2024. In relation to the text messages between the parents, of course, in the context of this case, where this mother, on her allegations, has suffered domestic abuse, rape, assault, and controlling and coercive behaviour, those text messages as between the mother and the father have to be seen in those contexts. And it's right to reflect, as my learned friend pointed out, at page 366, the text messages from the mother, "You have won," again, is, we say, important in the context of Dr. Ratnam's assessment of this mother's anxiety, depression, and mental health issues. In terms of the child's wishes and feelings, of course, the judge rightly discounted those, as did Miss Demery.
Sorry, say that again.
The child's wishes and feelings.
Oh, yeah.
The judge rightly discounted those because of his age and maturity, his maturity in particular, and his social needs, as did Miss Demery. And so the references to his wishes and feelings that my learned friend relies upon in wanting to go back to Ireland have no relevance, we say, to this appeal, and in terms where you're considering Article 13b only. It's important to put into context the allegations that my learned friend pointed to in paragraph 13 of the judgment, because they set out in very stark terms the degree and the nature of the allegations against the father. Abuse throughout the relationship, physical abuse, rape, coercive and controlling behaviour began in late 2016 when they first met and continued throughout the relationship. Whilst the judge makes reference to those being the most severe allegations, it's right then to contrast that with paragraph 114 of the judgment, which simply makes reference to the mother's allegations not reaching the high threshold required for Article 13b. In those terms, it's wrong in our submission to assert that the judge was finding the threshold or the Article 13b threshold could be met or should be read into the judgment, because in stark terms the judge rejects that at paragraph 114 of his judgment. My conclusion is that looking at the defence holistically and bearing in mind the protective measures offered, I have no doubt that the high bar set by the defence is not reached. Can I also direct you to the CAFCAS report? I don't know if you have this electronically or you now have a separate copy of
I
it.
think it was provided to us in paper.
I'm grateful.
Is that added to paper? Yes.
It's important, we say, to look at some of the evidence of the CAFCAS officer. I think I've now lost it. In particular, when one makes reference to the relationship between Daniel and Rachel, at internal page 4 of the report, Miss Demery is reporting aspects from Liverpool Children's Services, and the last paragraph, she relays the relationship between the child and his sister is also a concern. He's very protective of her, and if he perceives his sister to be at risk in any way, he will quickly go into crisis and hurt himself and others. There's no reference to that, and no reference to the relationship between the child and his sister at all, in considering the impact on the child of the separation from his sister if returned to Ireland. And of course, the court has to consider the impact on the child as of the date of the hearing, so in April of 2025, and Article 13b by its nature is forward-looking. We say and repeat that the judge simply failed to analyse at all the relevant risks to the child. And of course, when one looks at the CAFCAS recommendation as to why there should be assessment, the assessment's driven because of the allegations. Ms Demery is very clear that she does not and is not making a recommendation, but she's also not making any findings or providing an assessment herself as to those allegations. But her overall concern is that in light of those allegations, there must be some assessment to consider whether those allegations themselves are proved, but also the father's behaviour in light of those allegations in relation to his parenting of the child. And so when the judge refers to Article to Practice Director and 12J, there's no reference to those considerations within his judgment. And then, if I can direct you to page 8 of the CAFCAS report, forgive me. Sorry, page 12 of the report, paragraph 44. The written evidence of the CAFCAS officer was, very sadly in my view, the child has experienced harm in his formative years, which are adverse for children's development. A combination of mental health, reported domestic abuse and substance misuse of both parents of alcohol and drugs places the children in the highest category of risk of emotional harm. Professional involvement throughout. This is indicative of the vulnerabilities the mother continues to experience. Her support network is limited to the professional network. But then Ms Demery emphasises the impact of domestic abuse on children at paragraph 45. Domestic abuse is effectively child abuse, irrespective of whether a child directly witnesses it, and can have a devastating impact on children. They might struggle with forming secure attachments, leading to trust issues and difficulties in establishing healthy relationships. That's the point of the assessment. That's the point in which she emphasises in her report that in the last paragraph of her report over the page, paragraph 49, the court may also wish to be assured there are alternative interim care arrangements for the child pending a welfare investigation. Because without any assessment of those risks, without any assessment of those allegations, the safety and security of this child is simply an unknown. So in the context of this appeal, we urge you to grant the appeal, and we also urge you to dismiss the application, as my Lord's already made reference.
So you're inviting us not to remit, but to make the decision ourselves if
Indeed.
we decide the judge is
Indeed, and we make that point in our skeleton argument, my Lord.
Yes.
You've already emphasised the summary nature of these proceedings. You have, and it's a paper exercise on Article 13b, the evidence we say is overwhelming, that there is a risk of emotional harm to this child. A return to Ireland and separating him from his mother, primary carer and his sister would, on any objective view, be intolerable and present a grave risk of harm to him, a risk of harm to him in terms of his emotional stability, being placed with his father, an unknown quantity in terms of his parenting of this particular child with these particular needs. Lord, unless I can assist you further.
We're just going to rise for a few minutes, so please don't go anywhere.
No, sadly not. I interviewed.
Thank you all for your respective submissions. We are going to reserve our judgments. They will be provided to you, and we're of course very well aware of the need, the urgency, as soon as possible. And they're being provided to you for the usual purposes, namely to correct typographical mistakes, not to re-argue, and they, as you know, the limited purposes for which they can be used. And I think that's particularly important in this case. And as you know, it's potentially a contempt of court to use them for other purposes. We're confident that once you've received the judgments, you'll be able to agree the order, but if not, we'll deal with any outstanding matters on paper.
Thank you, Lord.
So thank you very much for your succinct but comprehensive submissions.